Let me make a very cruel example and say, let us say all of the people that General Masemula is charged with were dead, all of them. And therefore there was no question of them being charged with all the offenses, with any of the offenses you are seeking to rely on, and to suggest that General Masemula's charges are additional to. So General Masemula then has to be charged under the PFMA all by himself. So what would the PFMA charges be additional to? What would the PFMA charges be additional to? Nothing. You get my point?
Yes.
So it's on that basis that I say your attempt to just force the PFMA charges being additional simply does not work. Do you agree? It doesn't. It doesn't. Because all that General Masemula is charged with are the PFMA offenses. So when you look at him, those offenses, insofar as General Masemula is concerned, are not additional to anything, are not related to anything. It's just those PFMA offenses only. And you cannot force the additional by merely relating to charges faced by other people, charges that have nothing to do with him whatsoever. And the cruel example I give actually makes the point abundantly clear. Do you agree?
I agree, it makes the point clear.
Yes.
If you'd allow me to, and then I stop.
Yes, yes.
In the manner in which it transpires, the PFMA is in relation to, and that is as far as I take it, it is in relation to the serious complex corruption, commercial and financial crimes. If those had not taken place, there is no need for the charge to be preferred, PFMA or otherwise, against Commissioner Masemola. But that is as far as I can take that argument. And I just wanted the opportunity to explain where I took the in relation.
But for as long as... Oh, sorry, please finish.
No, I said
yes.
That is as far as I'm able to take it, because it is in relation to. Yes. Had those not happened, there wouldn't have been these charges.
Yeah. You see, for as long as you agree with me and you are not able to argue against my cruel example, that point simply does not work. It doesn't. Because if he was all by himself, you couldn't. It would be nonsensical to talk about additional, because it would be additional to what? Additional to what? Because that additional is a conscious choice of word by the legislature or the legislator. It's a conscious choice of word. Otherwise, they would just have said relating to these statutory, or rather, offenses arising from these statutes, and then the statutes would be itemized. The use of additional is because there must first be other offenses. Otherwise, additional simply does not make sense. You must accept that.
I leave it there, Chair.
Do you agree that otherwise...
I have to agree with your reasoning.
Sorry.
I have to agree with your reasoning.
Thank you.
I made the point I thought I need to make.
Yes,
it is based on my understanding. And I have...
Yeah, I suggest to you, or as other people would say, I put it to you that your reasoning in this regard...
will not hold water.
It simply does not. Thank you.
After he has received advice from the head of risk, he ignores that advice and allows SAPS to continue with this contract. I know I've said a lot, so maybe respond only to the last part. Assume that everything I said before the last part was just background.
So how I understand it is that from the time that he was informed by the risk officer,
yes.
General Matlo, he took quite a bit of time before he acted on the information and the advice given. And it is precisely because he took a long time, it is in that period that monies became released. That is how I understand
But
it.
do you accept that, like any of us, when you get opinion, you first have to consider it, you first have to apply your mind to it before you act? Because if you act in haste, you could be sued for breach of contract, you could be sued for failure to apply your mind. I mean, some of the issues we've criticized you for was blindly accepting briefings without looking at underlying documents to satisfy yourself that, you know, the Section 27 read with the Section 28 applications are actually consistent and they are relevant to the complaint of Mr. Adams. So one does not, in the normal course, you get advice today, you act immediately. In the normal course, you would apply your mind to that advice and you would ask questions if there's a need to ask questions. Because I don't see anywhere in General Matlow's affidavit where she says it took the National Commissioner 6 months after he was given the advice to act on it. Because that paragraph 9 says, I gave the National Commissioner advice and then he terminated the contract. So there's no suggestion by, if General Matlow is the complainant, there's no suggestion by General Matlow that General Masemula did nothing with my advice or he took inordinately long before acting on that advice. And as a result of his failure to act on the advice, there was the loss. How I read this affidavit, it says the 50 million is what was paid throughout, not after the advice was given. But the charge sheet creates the impression that the loss happened after the advice was given.
If I could just indicate, Commissioner, that I asked if there was only the 27 at the time when they had this matter. I'm given to understand that General Matlow submitted a preliminary report together with the Section 27 affidavit. I'm not sure if it is before the Commission, but that must be something that that would then have to be asked, as it might just give a different context, but I'm not seeking to take the point further in terms of the conversation, Commissioner Khumalo, between you and I.
But looking at only paragraph 8, do you accept that the General says, I gave advice to the National Commissioner, the National Commissioner acted on the advice? The affidavit does not say the National Commissioner failed to act or did nothing with the advice given to him.
I understand that.
Yeah.
Still on this issue, my concern in the debate about whether or not this falls within the IDAC mandate is that on the charge sheet itself, there is no allegation of corruption. You don't make that allegation in the charge sheet. The charge sheet and the charges are purely statutory contravention, PFMA, and working off the charge sheet as it is now, the impression that it creates, or that in my mind has formulated, is that there was no good faith intention to prefer a charge because it is justified, it is supported by the facts. This was just a scheme to get him arrested or present to court, to have him appear in court, and the purpose is achieved just by that fact alone. So you don't even get to the validity of the charges. Yeah, that's why we don't discuss with you whether there's merit in the charges themselves. That's for the court to determine eventually if it does. But that which is obviously, at least in my view, which is obvious from the charge sheet and must have been obvious to the lawyers in your office and to the prosecutor who approves those charges, it must have been obvious just on the charges that we are not making an allegation of corruption against him. How do we justify him being here? That must have been obvious. And accepting, because it's difficult not to accept that it was that obvious to the lawyers who dealt with this. Accepting that it would have been obvious to them that this charge sheet is wholly inadequate for purposes of our mandate. There has to be another reason why, anyway, you approved the charge. If you did do a prosecution memo, you were prepared to do the prosecution memo and say to the prosecutor, I think it said it's a DPP, and for the DPP to approve this charge as it stands without saying to you, hang on, go back, include corruption in there so that it falls within our mandate. To me, it gives the impression that the whole purpose of this charge sheet was to just have him appear in court. Just have him, let's create a paper that presents him to court and he becomes an accused with a consequence that we now publicly know happened, which is he was removed from his position, whether it's a leave or suspension, whatever, but he's not in office. And I say that, and forgive me if I'm repeating myself, I say that because it's inconceivable to me that a whole lot of lawyers who looked at this charge sheet, none of them said, hang on, we can't do this. This is not good enough for purposes of our mandate. If we want to charge him as involved in corruption, even your interpretation that you give to the chair this morning, if that interpretation had been discussed, it would find reflection in the charge sheet. However, inelegantly expressed, if the idea was that, well, you know, he's implicated in the corruption, even if it's just these sections, but that connection, it would have found expression here with a lawyer's eye. And that it doesn't find expression suggests to me it's because you couldn't do it. None of you could get to the point where an allegation of corruption is made or him is being linked to the other accused conduct. And for that, you couldn't go that far, but it didn't matter because the real intention was never to get a successful prosecution of corruption or a successful prosecution that comes under PRECA. That was never the real intention. In my view, the intention was, as I say, get him arrested with the spectacle that comes with it, get him charged with a consequence that naturally will follow, which is the minister, and hopefully even he, National Commissioner, would say it's untenable for me to remain in this position while I'm undergoing a criminal trial, and that was its only purpose. That's what it looks like to me. You may comment if you want.
And I do understand your reasoning, Commissioner Baloy, but at no stage was there an intention to make a spectacle of anything. The prosecutors looked at the case in its totality. And as I explained this morning, it relates to, I accept, the only part that I do accept is they didn't draw the link between the two. That in itself does not make the conduct malicious, and there was no intent to put him on show. It was to charge him as they did. That link is not there. That cannot be taken away. But it should therefore not be seen as it was used as an instrument. They still firmly believe in those PFMA charges as they put them, and in my discussions yesterday, I did highlight that the Commission does find we have, where is the link between the two, hence my explanation this morning. I took your point, but I have to clarify, there was never an ill intent. It might have been clumsily put in the way it is.
Or incompetently drafted.
Put, but that does not make for ill intent at all. Thank you, Commissioner.
Thank you.
Taken by Mr. Mansa on a date when they are all supposed to have been together, executing one function together with the prosecutor. It's not for me to determine, I'm sure that exercise will still be done through your engagement, on which is the right set of affidavits, supplementary affidavits. That is one example. Closer towards the end of the day yesterday, I'm given a file, and in that file, we have the Public Service Commission report, dated 2023, Commissioner Khumalo, which I see for the first time. I only allude just to these two because they're very pointed and they're very factual in the nature of what is before us. I have had to ponder why we find ourselves in this position as IDAC, and why, while I accept, and I don't think that there's meanness when questions are posed by the Commission about, but why you didn't know, you should have read. I think the Commission understands I can't read everything and won't know everything, and I do have to trust and rely on my people. And I sat with a conundrum last night of why weren't these things brought to my attention? And if, especially with the Public Service Commission report, which is somewhat quite different, it should have stopped the day the report came in, because it should have been brought to the attention of the ID to say, ID, look, we thought we have a right to investigate this, but here it is. It has been done. Findings had been made. That would have set that matter aside. That was not done. And now the question is why? Why wasn't I informed of the different statements? And what is the purpose then, chairs and commissioners, and forgive me if I'm rambling, but I have to think it out loud because it does not make sense. And I'm saying that there must then have been something else going on that I was not aware of. I cannot tell you what the something else was. I wish I could. I'm not therefore disagreeing with your counsel. I just needed to put it in a way that I am able to, unfortunately, not reconcile, but try and understand about what it is that was going on. You can't reconcile yourself with bad when at all times, I know that I made mistakes as the head of ID, non-intentional, and a lot of them are perhaps administrative things. But at no stage did I apply my mind in a way to seek to to vilify anyone. And so when you don't always have the full knowledge of things, I think the challenge I sit with commissioners is, how will we as IDAC will only be 2 years old on the 19th of August. And as a young institution, what will be the mechanisms that have to be put in place for these underlying hands, persons and personas not to have the kind of influence there seems to have been had? I'm unable to take it further than that.
What could the something, as you put it, possibly have been? Surely you must have your ideas. Because one could easily say it was improper motives. But I'm not necessarily suggesting that. I want your own thoughts. What could the something possibly have been?
The something, Commissioner, I take it also from my time at the DSO, the Scorpions as they were. A lot of the times, and history had shown that, you find that staff get overzealous in wanting to present their case. But more often than not, you find that they engage with persons outside the purview of the work we're supposed to do, and you are not privy to that engagement. Mm-hmm. And so the mind you expect them to bring to bear on the mandate and on the cases is what you're engaging them on. It has been a past experience. In the way things happened this past week, it seems that there are other actors that might have been engaged with for us to be where we are.
And when you talk about other actors, are you talking about undue influence, perhaps?
I don't want to put it so harshly without having any, but to say that persons might have, for motives known to them, cast certain narratives or provided certain information. And you find that without of necessity, because what you expect, everybody gives information. Lots of people like to say lots of things. Do you verify it? Do you consider the source? And do you ever stop to ask, why did that source come to you? It is a question I've had to ask in this very painful few days you've had with me on the Section 27 referral of Adams. How it came about, what was the purpose, and look at where we are today.
But you cannot seek to extricate yourself as you appear to try to from what happened, especially with regard to what you just referred to, which is the Section 27 referral. That was there for you to see, and right from the first day, we took you through that document, and you agreed when I suggested to you that it had open quote nothing close quote. You accepted that when I so suggested to
Correct.
you. So you cannot seek to say others may have acted wrongly. I will say to you, you too acted wrongly. And if there are questions to be asked about why, those must relate to you as well.
Correct.
On a document or on an affidavit that had nothing except for factual conclusions, you acted. It had to be your decision, you as the head of IDAC. It had to be your decision, and indeed it was, for any investigation to have gone on in the first place. Cut a long story short, I do not understand why you would want to blame others.
If I may.
As it should have, the buck stopped with you. And indeed, from where I'm sitting, it did.
And that is why, as I was carrying on with the Adams matter, that brought starkly home, from start to finish,
Yes.
the responsibility across the board.
Yeah.
In the first two instances, there are different instances that I used, as I hadn't been aware of them. But I sit here today knowing that I have to take responsibility
Yes.
for all the actions that flowed, intentionally or unintentionally. And I will be judged for those actions.
Yes, but why I'm going back to where we started on the first day of your testimony is because in the context of blaming others, you are referring to the Section 27 affidavit. And it is in that context that I say you cannot blame others.
It is my responsibility.
It is and it was your responsibility.
I accept that, Chair.
Thank you.
Thank you, Chair. Thank you. Advocate Johnson. As I indicated, I would like to move to a different topic. I have a few small topics to cover with you quickly, and I hope we can wrap that up in an hour. We now have it wasn't a promise, but a new hope that you'll be done by lunch. I hope to at least deliver on that one. Okay. The next issue is, do you have your statement filed close by? And in particular, the first October 25 statement. And